Good morning. I'm glad to see many people are starting to sign on. Give it a few more minutes for sure to let more people sign in. Hope everybody's doing okay this morning.
Well, our guest of honor made it in, so we're off to a good start.
Indeed.
Who knows how the rest of the day or weekend's going to go, but at least we're off to a good start in our little part of the world.
Hi, Greg.
Hey, Bob.
Dream.
Greetings.
Good morning, Greg. Good morning, Steve, and everybody.
Lois.
Lois.
Good morning from Troy, Ohio. Deb Hogshead here.
Hello, Deb.
Deb.
Where are you from?
Troy.
Troy, Ohio. That's in the south.
Well, no, I guess it's the southwest corner, but we're north of Dayton.
Okay. I think of it that Dayton is south.
Okay.
Southwest. Right.
Yeah, when you're in Cleveland, then everything is south.
That's
Yeah.
right. That's right.
I was always surprised to learn that Akron is Southern Ohio because I'm in Columbus, where Akron is Northeast Ohio.
It is Northeast Ohio. It should be.
Yeah, it is.
People call it
right.
Southern Ohio.
Really?
Well,
Part of
people-
that is because historically, so many people from West Virginia moved to Akron to work in the rubber factories.
I see. I never thought of Akron as Southern Ohio.
In fact, people running for office in West Virginia would come up to Akron to campaign.
I see the recording button has been hit. Gonna give it a couple more minutes before we get started. Yeah, let me know when if it starts to trickle down the number of people coming in.
Yeah, okay. Yeah, a lot of people registered for this.
Yeah, I'm guessing most of us are pretty comfortable with Zoom by now, although I did have somebody email yesterday saying they, didn't have Zoom and asked, if there were any other options. So that's why we're recording.
Yeah, good idea.
One of my first Zoom events, I signed up for a lecture at The Ohio State University and didn't realize I have to have a Zoom link to be able to attend that event. Now I know that, but this was in like March. I don't think the
Yeah.
organizer was completely organized, so they didn't say, here's your link either.
There are a lot of complexities with Zoom.
Yeah.
Yeah, just now I tried getting on it through WhatsApp, and I instead got the WhatsApp site rather than this site. So that,
Well, just as an FYI, this is, as Steve mentioned, is being recorded, and we'll send the recording out to everyone who both is on this call and who registered, and will be linked to our Facebook page and the Move to Amend Cleveland webpage, so that you can share it far and wide, since it is deserving to be shared far and wide.
Yeah, and just want to feel free to put any comments you have, or especially questions, in the Zoom chat at any time, and we'll monitor those and for the Q&A at the end of the session.
This is my first Move to Amend Cleveland event. And as a non-driver, I've always felt a little bit inhibited or not able to get around, but now with Zoom, I can go almost anywhere.
Yeah, that's one thing that's been great about the pandemic has been, virtualizing across location.
I attended a lecture about redlining, which might be the right term, on the Case Western Reserve campus, but it was virtual, so I just stayed here in this same apartment.
Well, what do you think, Steve? We're sort of at 5.
Yeah, it's 5 after, so it seems like most people are here by now. I'll kick it off. I'm Steve Norris. I'm one of the co-chairs of Move to Amend Cleveland, along with Lois Romanoff. I want to welcome everyone here today to talk about this. Move to Amend is a grassroots national organization to end money as speech and corporate constitutional rights, which would allow us to have a better democracy. And I wanted to turn it over to Greg Coleridge, does outreach for Move to Amend, and he can do the introductions.
Well, great. Good morning, everyone. Appreciate you all being here. Some of you, when would it have been? Gosh, time is strange these days, but a couple of years ago, Keon Bliss, who is National Move to Amend's Outreach Director, came to speak at a gathering at the Cleveland Heights University Heights Public Library as part of a barnstorm speaking tour around the state on issues of the intersection of race and corporate power and the Constitution. And on the panel, among those who spoke following his keynote presentation was Tyrone Taylor. And I'm getting a note, a call, somebody who obviously can't get in. So let me just decline that for a second, and I will call them back when I'm done with the introduction. So Taru Taylor spoke, many of you may have remembered that, very eloquently about his impressions and reflections on the intersection of those issues. He has continued his work in many different ways in that sort of theme. I am just posting in the chat right now his page on Truth Out. Don't go there now, but just copy the link, okay? And that is where you will find a number of his articles over the last couple of years to be read later on many different issues, but overall sort of seeing the intersection between issues of race, the Constitution, democracy, and corporate power, corporate rule. Some of those articles connect all of them, while some deal with any combination of those. Taru is a recent law school graduate from Greater Cleveland area and has most recently, within the past, gosh, I don't know how long this campaign's been going on. Taru, you will share that, been involved with others in the Greater Cleveland area to sort of lift up educationally, advocacy-wise, and organizationally to try to call attention to and bring pressure to bear on Cleveland State University Corporation to try to force them to change the name of their law school from John Marshall to something else. And so he will get into that. Appreciate very much, Taru, you taking time to be with us and to share. And sort of after your presentation, we'll open it up for comments, questions. We just ask that people try to limit, out of respect to the speaker, the comments sort of in the chat that sometimes can be a diversion and take away from the concentration necessary. Since some of these issues, let's be quite frank about it, can be things that we're not all that familiar with, since we don't learn about this stuff. I didn't, most of us don't, in school, in our activist circles and the like. So it does require, to a certain extent, some focused attention. So anyway, Drew, take it away. And I'm going to place myself on a chat here to call someone back. Welcome, Drew.
Thank you, Greg. Thanks for the introduction, and happy to be here this morning to discuss this John Marshall controversy, especially in light of the events last Wednesday, January 6th. So my talk, which should be about 20 minutes, will definitely put this John Marshall issue in context of last week's events. And so, I'll just go ahead and get started now. And my talk, I've called it The Reckoning. Last Wednesday, January 6th, we witnessed a rebirth of the Confederate lost cause. The stars and bars flew in the Capitol building for the first time. The nation, and indeed the world, witnessed the spectacle of President Trump inciting a neo-Confederate insurrection. Meanwhile, over 1/4 of Congress, 8 senators and 139 representatives, voted to disenfranchise 81 million people. Senator Ben Sasse, a Republican from Nebraska, called out his seditious Republican colleagues as, quote, institutional arsonist members of Congress, end quote. The Confederate flag that we all saw unfurled in the Capitol resonates with the name John Marshall. They both symbolize slavery and hardcore white supremacy. What Chief Justice John Marshall stood for then, the neo-Confederate insurrectionists stand for now: Aryanism. But 240 years ago, John Adams had said that, quote, ours is a nation of laws and not of men. In his mind, the rule of law had replaced the divine right of kings. But what really replaced the divine right of kings on July 4th, 1776, was the divine right of wealthy white men. A week and a half ago, we saw police officers taking selfies with members of the lynch mob during the insurrection. And lynch mob it was, for insurrectionists were chanting, hang Mike Pence, and had put up a rope to lynch him. Can we imagine police officers taking selfies with Black Lives Matter protesters last summer? Today, I'm going to trace that double standard of police persecution of Black people and their allies on the one hand, and they're rolling out the red carpet for neo-Confederate insurrectionists on the other hand, back to 1810. For in 1810, John Marshall decided 2 cases that make the double standard of American law clear. Natural rights for white men, especially of the 1% class, on the one hand, but no rights that white men are bound to respect regarding the Negro, on the other hand. The lawless law enforcement whereby police officers rolled out the red carpet for insurrectionists last Wednesday reflects John Marshall's judicial lawlessness. Now, John Adams best expressed the rule of law, which I'll quote again. Ours is a government of laws and not of men, to which we should add women, of course. But what does rule of law mean? The rule of law comes down to equal justice under law, as engraved on the Supreme Court building. In other words, every person should get their due regardless of race or sex or creed or socioeconomic status. A legal maxim that defines the rule of law is, no one should be a judge in their own cause. In other words, a judge shouldn't decide a case if they have a conflict of interest. In Federalist number 10, James Madison gives a masterclass on how factions and their vested interests define politics. He argues that government must protect the people against the dangers of faction. It must secure the public good on Republican principles. He says that regulation of varying and competing interests is the main task of legislation. Speaking of governors and vested interests, he says, quote, "No one is allowed to be a judge in his own cause because his interest would certainly bias his own judgment and, not improbably, corrupt his integrity," end quote. Alexander Hamilton in Federalist number 80 makes the same point with reference to federal courts. Hamilton said, quote, "No man ought certainly to be a judge in his own cause, or in any cause in respect to which he has the least interest or bias." A classic example of this legal maxim is Dr. Bonham's case from 1610. In this case, the Royal College of Physicians charged Dr. Bonham with practicing medicine without a license. The college tried Bonham in its own court and found him guilty. It imprisoned him and fined him. It proposed to pocket half the fine, but Sir Edward Coke reversed the decision. Regarding the fine, here's what Coke said. He said that physicians, quote, "cannot be judges, ministers, and parties. Judges to give sentence or judgment, ministers to make summons, and parties to have half of the forfeiture," end quote. He explained why. He said, "Someone ought not to be a judge in his own cause, for it is unfair for someone to be a judge in his own affairs." Coke went on to equate the common law with the law of the land. Dr. Bonham's case thus stands for the principle that any act of Parliament that is against reason may be voided through common law. John Marshall restated the principle in terms of American law. Quote, "A law repugnant to the Constitution is void," end quote. He did this in Marbury versus Madison, the most important Supreme Court case ever because it established judicial review. This gave the court power to declare legislative acts and executive actions unconstitutional. We, the people, have the right to impartial judges and juries in civil and in criminal court. The Sixth Amendment speaks to our right to an impartial jury in a criminal trial. The Model Code of Judicial Conduct states, quote, "An independent, fair, and impartial judiciary is indispensable to our system of justice. The United States legal system is based upon the principle that an independent, impartial, and competent judiciary composed of men and women of integrity will interpret and apply the law that governs our society," end quote. I'm going to now show how John Marshall embarrasses American law insofar as its judges and lawyers pretend to impartiality and the rule of law. I'm going to juxtapose two cases from the year 1810, Fletcher versus Peck and Scott versus Negro Ben. Starting with Fletcher versus Peck. Fletcher versus Peck was a landmark case involving a land grant scandal. Corrupt legislators from Georgia had enacted the Yazoo Land Act in 1795. Even though state legislators had been bribed, good faith purchasers bought lands in what later became Mississippi and Alabama. Now, a subsequent state legislature passed a statute to rescind the grant and to nullify the land contracts pursuant to it. The Supreme Court ruled that the statutory repeal was unconstitutional. Therefore, the land contracts were valid. Marshall reasoned that the legislature had passed an ex post facto law and had impaired the obligation of contracts, this from Article 1 of the Constitution. But Marshall didn't stop there. He concluded by way of natural rights, quote, "When, then, a law is in its nature a contract, when absolute rights have vested under that contract, a repeal of the law cannot divest those rights," end quote. Now, the plaintiff, Robert Fletcher, had purchased 15,000 acres from the defendant, John Peck, in 1803 for $3,000, which is about $60,000 today. Now, clearly the litigants were wealthy white men, from the South no less. So little surprise that Marshall invoked natural rights. Natural law has a prominent place in courts where the litigants are of the 1% class and their disputes turn on either contract law or property law. The court reserves absolute rights for the likes of Fletcher and Peck. But as we'll see in the case of Scott versus Negro Ben, later on, the infamous Dred Scott case reflected the truth of American law when the court said, quote, "The Negro has no rights which white men are bound to respect." And so now to discuss Scott versus Negro Ben. Of the 14 freedom suits that came before the Marshall Court, Marshall himself wrote 7 opinions. These freedom suits concerned Black people living in Washington, D.C. As federal territory, it was within Supreme Court jurisdiction. If Marshall had respected legal precedent in these cases, he would have applied Virginia or Maryland law to alleged slaves living in Washington. But Marshall repeatedly ignored stare decisis to rule against Black plaintiffs. He never construed statutes if doing so led to Black freedom. We must remember, as a way of background, we must remember that slavery at the turn of the 19th century brimmed with ambiguity. Neither the common law, nor judge-made law, nor the Constitution accepted slavery. The notion of, quote, property in man, end quote, or a person owning another person as property was unconstitutional. Slavery was tolerated, of course, but only within the narrow context of local positive law. Slave statutes were unlawful even though they were tolerated. Moreover, in the first few decades of the Republic, many Black people did have the right to due process. Freedom suits abounded. But Marshall lawlessly ignored the Negro's common law right to the presumption of freedom. Meanwhile, concerning white men, Marshall equated property rights with natural rights. In favorum libertatis, that's Latin for in favor of liberty. This denoted a presumption of the common law, that people are free unless they are proven otherwise. In favorum libertatis is similar to the accused person's presumption of innocence, which imposes the burden of persuasion on the prosecutor. The prosecutor must prove beyond a reasonable doubt that the defendant is guilty of crime. Likewise, in favorum libertatis imposed the burden of persuasion on the supposed slaveholder. They had to prove that the Negro in question was a slave, much like medieval feudal lords were burdened with proving that a person was a villain or serf. According to the common law, all persons are presumed free. The quote unquote slave is a creature of statute. As we'll see, Marshall lawlessly presumed that Negroes were slaves. The common law provided the norms against which the Constitution and statutes were tested. In fact, the 7th Amendment incorporates the common law explicitly. From July 4th, 1776 until today, American law has more or less been a continuation of the common law that was established as early as the Magna Carta in 1215. The common law never countenanced slavery. The Constitution's framers studiously avoided any mention of slavery. at least until 1865. And yet slavery was permitted in the colonies that just 4 years after the Somerset case became the United States of America. Now, the Somerset case of 1772, this is the case where Lord Mansfield held that slavery was unjust, bearing in mind that at the time, the colonies were still part of Great Britain. More specifically, Mansfield held that common law prohibits slavery, and slavery is so, quote unquote, odious that only local positive law can support it. Somerset was part of the common law from the day it was decided on June 22nd, 1772. It defined the law of the land regarding slavery. Somerset therefore set the standard against which to measure the lawlessness of Marshall's pro-slavery jurisprudence. Moreover, Marshall defied the Ninth Amendment rule of construction that mandates that judges not deny or disparage the rights retained by the people. Slave laws in slave states did overrule the common law, but only within local context. Even so, the common law default was Black freedom. Again, in favorum libertatis. By the time Marshall heard the case Scott versus Negro Ben in 1810, Somerset was still the law of the land. Maryland law, and Maryland law was the relevant law in this case, because in the jurisdiction in question, Maryland law held. And Maryland law required that slaveholders new to the state register their slaves in due time with certain public officials. So newly arrived slaveholders had to follow statutory procedures to keep their slaves. Sabret Scott, the defendant in this case, failed to do so. He failed to follow the statute. The plaintiff, a Negro named Ben, sued for his freedom. He won. The jury set him free. And mind you, this jury probably had several slaveholders on the jury, but the jury nevertheless set him free, having evidently followed the logic of in favorum libertatis. Mr. Scott simply had failed to prove Ben a slave. Yet Marshall reversed the verdict. Again, slavery was prohibited by common law. Furthermore, it was unconstitutional. And the jury had determined that Ben should be free in terms of the relevant Maryland statute. But Marshall thought that the statute was ambiguous. He said so himself in the opinion, quote, "The act in its expression is certainly ambiguous, and the one construction or the other may be admitted without great violence to the words which are employed," end quote. But because of the common law presumption of freedom, Marshall should have resolved the ambiguity in favorum libertatis. But as can be expected from a man who owned 200 slaves, Marshall resolved it in favor of slavery. Again, he reversed the jury verdict. And so, John Marshall held that Fletcher and Peck enjoyed natural rights to contract. That very same year, he lawlessly refused to respect Ben's right to the presumption of freedom. Nor was Scott versus Negro Ben a one-off case. Marshall held court in some 50 cases involving slavery. He was always pro-slavery. The quote, "great Chief Justice," unquote, thus set the paradigm of institutional racism in our courts that later culminated in Dred Scott. 2 centuries and a decade after he decided Fletcher versus Peck and Scott versus Negro Ben, 4 officers of the courts of Minneapolis extrajudicially murdered a man in broad daylight named George Floyd. This double standard, natural rights for wealthy white men, presumptive slavery for Negroes, is the essence of institutional racism. Our courts conduce to due process for white men and their unjust enrichment at the expense of Negroes. Presumptive slavery for Negroes then, presumptive guilt for quote unquote African Americans now. The court lawlessly denied Black presumed freedom. It now lawlessly denies Black presumed innocence. Negro Ben foreshadowed George Floyd and Breonna Taylor. Confederate flags should not fly in our corridors of power, and nor should the name John Marshall name any of our institutions. Thank you.
Awesome, thank you.
Yes, that was wonderful.
Thank you. Questions, comments?
I'd like to hear it again. Oh, gee. So the law is actually in favor of killing Black people? It's okay to kill a Black person?
Is that a rhetorical question or?
I'm asking. Is it all right to kill a Black person? By the law?
Well, so I think one way of answering the question, one of the basic fundamental precept of law is wherever there's a right, there is a remedy. And so if you have the right to life, then that means that if someone were to take your life, then there should be some sort of punishment or remedy or protection of that right. And so insofar as Black people throughout the history of this country have often been murdered and lynched, and people have escaped punishment, and people have not been punished, or there have been no remedies for the taking of Black people's lives, that would suggest that American law does not respect the lives of Black people.
See that regularly.
So that's where the lawlessness comes in, and that's part of my understanding of Black Lives Matter. That statement is pushing back against American law, which has condoned the killing of Black people. For the most part.
Well, I know there's quite a bit of interest, Taru, in hearing about the campaign related to the renaming of John Marshall Law School. But before we get into it, I have one question, which has to do with, is not the Fugitive Slave Clause, Article 4, Section 2 in the Constitution, something that is embedded, is that not an affirmation of slavery that is part and parcel part of our Constitution?
So yeah, clearly there are several provisions, including the Fugitive Slave Clause, that conduce to slavery and that support slavery.
Can you just say what that is real quick, in case people don't know?
So it's in, I think it's in Article 4.
Right.
And that's the clause in the Constitution whereby if a slave escapes let me just quote it. I have the Constitution right here. Instead of paraphrasing, it's always best to just quote it. It says, "No person held to service or labor in one state under the laws thereof, escaping into another, shall, in consequence of any law or regulation therein, be discharged from such service or labor, but shall be delivered up on claim of the party to whom such service or labor may be due." So, and so part of, now I didn't really get into this in the paper, in my talk, but there is, now just from a strict construction of the Constitution, slavery is not mentioned, at least until the 13th Amendment. And so slavery is outside of the context of the Constitution. But even here, it talks about service or labor. So that could refer to indentured servants. That couldn't refer to laborers. Now, clearly the reference is largely to slaves. And another example is the 3/5 clause. And the 3/5 clause is really what the slave lords of the South dominated the federal government until the Civil War, largely thanks to that clause, whereby 60% of the Black population were counted towards apportionment of representatives in Congress, the Electoral College. And so most of the presidents until Lincoln were Virginian slave lords. And Congress and the Supreme Court justices dominated the federal government thanks to the 60% engorgement of their power. But again, strictly speaking, the Constitution does not reference slavery. And this goes to another point, that James Madison and the Washington and Franklin, et cetera, they recognized that slavery was evil. In their mind, slavery was a necessary evil. Whereas later on, from the 1830s, John Calhoun and then Taney, in the Dred Scott case, they saw slavery as a positive good. And so one of the distinctions is that the Confederates saw slavery as a positive good and were totally unapologetic about it. Whereas Jefferson and people of the previous generation, they recognized that it was evil. And they did not want that in the Constitution. Even though, of course, they, so that's one thing to keep in mind.
Mr. Taylor, is slavery, you said slavery is not in the Constitution anywhere, but presumption thereof is, but how can this be eradicated?
How can what be eradicated?
To change the wording or to change what you just said. Seems like it's in there. Like if you baking biscuits, you don't know everything that's in it, but it's in there. But it's just like, can we somehow, how come everybody don't see that? And with the Constitution now, and can it be ever changed or in any way?
And improved.
Improved, yes. Not changed, yes, improved. Thank you. I didn't mean to say change.
Well,
yes,
well,
improved.
Actually, I mean, my answer to that would be going back to the equal justice under law, and that we really have to take our right to impartial judges and juries and lawyers seriously, which is to say that judges should be impartial. They shouldn't have conflicts of interest. And I spoke to the conflicts of interest that Marshall had. I mean, the man owned 200 slaves, and he and a lot of their so they were distorting the law to their purposes. And so what we today in 2020 or 2021, sorry, in 2021.
That's all right. This is the 13th month of 2020. What's going on? That's all right.
And so let me give you an example. So here in Cuyahoga County, there are 34 judges on the Cuyahoga County bench, as far as the Court of Common Pleas. Now, 4 years ago in my class, I took a criminal procedure class, and my professor told us that 26 of the 34 judges were former prosecutors. And he said that the other 8 were former corporate lawyers. And so as of, this was in 2016 when I took the course, there were no public defenders, no criminal defense attorneys. And so that's an example of where the court is biased in terms of prosecutors, in terms of law and order as understood by Donald Trump or Richard Nixon, law and order with this kind of police state impetus. And so it's hard to, and so when really the courts should reflect, and this is where I've mentioned James Madison earlier. He says that government in general should regulate between competing interests. And Madison talks about debtors and creditors and various class interests, and that the court should be impartial to these things. But throughout history, we've seen judges ruling for the 1% or people in the ruling classes against not only Black people, but against people of the 99% in general, against the laboring classes. And so really, it's not so much a question of the text in and of itself, but having legislators and judges that reflect the varying interests in our society. And that's just not the case, even to this day.
Okay.
Don Bryan in the chat says, I've heard that modern day policing originated with authorities chasing down escaped slaves. Is there a direct line that can be traced?
So there definitely is, as far as slave patrols, that's what I think Don is referring to. Now, the modern police departments, as I understand them, are mostly modeled after the London Police Department that was established by Robert Peel. I think that was in 1829 or 1830. And so Boston and New York, they established police departments based on that model. But yeah, for sure, in the South, policing is, from my understanding, derives from the slave patrols.
Well, can you get into the what's happening with Cleveland State and the effort there to try to change the name?
So, I mean, the last update really was when I spoke with the dean, and the dean told me that there would likely be a vote on this issue sometime this year. Sometime this year, there should be a vote on whether or not to change the name. Now, the issue there, though, is, again, this comes back to the conflict of interest issue. The president and the board of trustees of Cleveland State are the ones making this decision. And these people are mostly wealthy white men, or men who are of the 1% class, or within that framework. And so here you have white men deciding this issue of whether or not this Virginian slave lord should name this school. So that's so even in 2021, we're still dealing with this conflict of interest problem, because it's not like the decision makers are reflecting the larger community. Now, Cleveland State is a public school, and Cleveland is 53% Black. And Cleveland, I mean, and there are all kinds of varying classes of people and different interests and perspectives, but yet the people making this decision about this public school are the president and the board of trustees, the big shots, basically. So that's really, I think that we really, going forward, as far as the rule of law and equal justice under law, we really need to home in on this problem of impartiality and how so many people in these positions of power reflect a very narrow segment of the population.
Amen.
Farrell Brody in the chat said he went to Franklin and Marshall College in Lancaster, PA. I presume that is named after, so said the same Marshall. Do you know anything about whether anything's going on there or not? Have you heard anything, or have you communicated with people there?
Good question. Yes, it is John Marshall, and another slaveholder, Ben Franklin. Now he wasn't on the scale of John Marshall, but nevertheless, he was a slaveholder. And so you got a double whammy there, Franklin and Marshall. I don't know about what's going on there.
Well, maybe Farrell, you can drum up as a alum, get some mischief making going on there.
I would love to do that.
Oh, great.
It's just amazing to me that you have to drum up anything to do anything in America. It's always got to be an uprising. It's always got to be, nobody can just sit down and talk about what really needs to be done and look at it in a logical way and say that it's wrong. They have to, I mean, it's America. I'm 72 years old. I just want to put that out there. And I'm just like living now in these times with what Trump has done and how people are thinking. It's just amazing that, I mean, if I can understand and see things, why are these people that are in high places so dense?
Well, I mean, I would suggest, and again, this part of the point with this axiom of the law that you shouldn't judge your own case, because that's automatically unreasonable.
Yes.
When you are biased, when you're judging something that is going to affect your own interests, that's automatic, that's unreasonable.
Right.
And so part of the problem is we have, like, for example, I saw this statistic that as far as members of Congress, so the US population is 33% white male, whereas Congress is 77% white male. And I saw another statistic that said something like 5% of the population are millionaires and 51% of Congress are millionaires. So there is so distorted, and these people are legislating, making decisions based on their interests as millionaires, as white men from that particular perspective, and so there's a certain lack of balance or regulating competing interests that's going on. And I mean, and that's the insanity of 1/4 of Congress voting to overturn the Electoral College. And it's funny because I was watching some of the debates about impeaching Trump the other day, and I kept hearing cancel culture. I kept hearing cancel culture this, cancel culture that. These people tried to cancel 81 million votes, and they're talking about cancel culture. It's so insane. And I would say that it's part of it is that they've been spoiled. I mean, the fact that they dominated the federal government because they were parasites, political parasites on Black people. These Black people couldn't vote. These Black people were totally disenfranchised, and yet they used 60% of their numbers to engorge their own representation in Congress and the Electoral College, and they got spoiled by that. And it's just going back to white privilege. I mean, it's so. So I think it's not so much, again, it's not the law or the text of the law in itself that's the problem. It's the people making the decisions. They should be more reflective of I hate to use this word, but the diversity of our of our nation.
Deb mentions in the chat, what about Marshall University in Huntington, West Virginia? Any efforts to change that school name that you know of?
Another great question. I don't know. I'm only really aware of Cleveland Marshall here in Cleveland and John Marshall School of Law in Chicago. I know that, in fact, a man named Hanakasis, he started a petition to rename John Marshall based on his school. He's an alumnus of John Marshall in Chicago. And so that's how I first found out about John Marshall and his being a Virginian slave lord and all of that. And so,
did he get anywhere with that? Did he make any progress? So
they're similar, parallel thing, like they're voting on it this year as well. So
that's good.
So yeah, so John Marshall in Chicago, Cleveland Marshall here. I don't know there's one other law school that I know that's named after John Marshall, and it's in Atlanta. And I'm not aware of anything going on down there. But I should mention that there was a Newsweek story about in Marshall County, Alabama. People were protesting. In fact, they put 150 body bags to symbolize John Marshall's slaves in protest of the name of the county, John Marshall, and also the Confederate flag that was flying in the courthouse or whatever. And again, there's definitely the name John Marshall and the Confederate flag symbolize the same white supremacy, hard slavery, just that sort of thing.
Yes,
Back in the chat, going back just a bit to the comment that Brian originally made about policing and the origin of the police, the slave patrols. Brian Houlihan responded to that, talking about the Second Amendment was ratified with the understanding that the slave states could formalize their, quote, well-regulated militias for purposes of establishing slave patrols to capture runaway slaves and prevent slave insurrections. And then he continues, our present day police force retain remnants of this original acceptance of these, quote unquote, militias. Comment on that.
Yes. In fact, I believe that in 1790, there was some act that was quite explicit about white militias. So it was explicit. But you know, one of the things about modern policing is there's a very real question. And Radley Balco, he wrote a book called Rise of the Warrior Cop, the militarization of today's police forces. And in it, it's interesting because the first sentence of the book is a question. Are cops constitutional? And he explores that question. And it's a real question because, I mean, if we look at it from an originalist standpoint, there were no police officers as we now know them in 1788. The police as we now know them, again, these came about in the 1830s, and they were emulating the London police of Robert Peel. And so, and if we look at the part of the point of the Fourth Amendment was it was a reaction against the military policing of the Redcoats. That the Redcoats, they put, the British had general warrants. They were totally oppressing the colonists with general warrants, and so the Fourth Amendment was meant to protect the people against this type of military policing. And it's interesting because one of the things that Radley Balco reflects on, he says, the Constitution is very good about protecting the people from the military acting as police. But he says, the Constitution is not so good about protecting the people from the police acting as the military. And he says that's where we're at now, that even though, like, we don't think of the National Guard, or which is kind of like the modern day incarnation of the militias, the National Guard. We don't really think of them as policing the people, or the Army or the Navy and such. But SWAT teams, police in these battle gear, tanks, and the police really are military.
Right.
And so that's what we're up against. We're up against not so much military acting as police, but police acting as military.
Yeah. I'm sure people would be interested in knowing what you feel would be useful and constructive that we all could do to put some fire under the feet of the folks at John Marshall. But before doing that, I wanted to bring up, since we all The group sponsoring this is Move to Amend, which, as people may know, focuses a lot on the hijacking of constitutional amendments by corporate entities that were never intended for them. But there was also a sort of abuse of the original, I guess you could, or creation or abuse of the original Constitution by corporations that was originally decided by John Marshall. And I'm wondering if you could say something about the contracts clause in the decision of Dartmouth College versus Woodward, which was a case in which, and why this is important. I mean, just as people may know who have heard us ramble on about Move to Amend and the importance of the ability to control and define corporations, that definition and that authorization to initially define what corporations could and could not do was done through the vehicle, the democratic medium of charters, which was one-way authorizations by we the people, by those who we elect to say, here's what a company can and cannot do. And if you want to accept these terms, you incorporators, fine, but we're doing the defining. So take it or leave it. But when you start shifting that from a charter in which it goes one way to a contract, now by definition, what a contract is, it's something to be negotiated. Now all of a sudden you have not a relationship that is superior to subordinate, but a relationship is between co-equals. And so I was just wondering if you could say something about, elaborate more about that, why, in a sense, that was so problematic then, and the implications of that today, in which we still find, corporations being able to get away with doing whatever the hell they want to, using as a shield the contracts clause that goes back again to our friend, John Marshall.
Sure. Well, the Dartmouth case, a lot of the logic or reasoning that Marshall used in that case actually goes back to Fletcher v. Peck. And in Fletcher v. Peck, I mentioned this Yazoo Land Act in 1795, and there was all kinds of corruption going on there. And so the Georgia legislators tried to do the right thing, actually. they tried to nullify that and to frame these lands in Mississippi and Alabama. But they were trying to look out, in their mind, it was an issue of the Republican governance and the public good, as opposed to all of these people just buying up all these lands and disenfranchising the people. That's how it was framed. And the understanding was that the contract, like government should have the power to police these kinds of things. But John Marshall ruled that these contractors were essentially above the law. And so he framed contracts in terms of natural rights, absolute rights. And then later on, with the Dartmouth College case, the issue was whether or not this Dartmouth College, whether or not it was a public, because at the time, corporations were understood to serve a public purpose. And that government, it was within the right of government to police corporations to make sure that they serve the public good. So they were creatures of statute. And essentially, John Marshall ruled that the corporate charter, instead of being for the public good, was a private contract, which kind of went against the previous understanding of corporations. And so pretty much it was as if, so John Marshall used the contracts clause, the obligation of contracts, in terms of natural rights for people in this 1% class. But really, obligation of contracts, this should imply mutual obligation. It shouldn't just go one way. And so, I mean, that gets into issues of the, I mean, I've argued in the past that we should use the obligation of contracts clause to protect employees. That whenever you sign a contract to work for an employer, that implies mutual obligation. But in our at-will employment regime, the vast majority of employees are at-will employees that can be fired without cause at a moment's notice. And so there's no mutual obligation there.
Right.
The obligation only goes one way. And so in a sense, Congress is failing the American people because they're allowing states to pass laws that conduce to these oppressive, invalid contracts. I would argue most contracts, employment contracts, are invalid because every valid contract implies mutual obligation. But here's an example of the double standard. If we had more everyday regular folks in Congress, I imagine we would have legislation that reflects the mutuality of contracts. But because it's so one-sided, it only goes one way.
Right. Exactly.
You know, the employee is obligated to do whatever for the employer, but the employer has zero obligations with regard to the employee, except to pay the employee so long as they're employed. But yeah.
Yep. So just to finish this up before we get into what people can do. So the mere fact that because Marshall ruled the way he did in sort of affirming or in a sense redefining the charter of Dartmouth College and upholding that or redefining it as a contract, because the state of New Hampshire wanted to convert it to a university. So by not being able to do that, it weakened the ability of we the people to use the charter as a democratic defining tool. And after that decision, it weakened the ability subsequent, which still stands today. So our ability as self-governing people to ultimately define what corporations can and cannot do via the corporate charter has been weakened, and it goes all the way back to that decision of John Marshall. We tend to think that it's the Santa Clara decision of 1886. That was the very first time, and yeah, in a sense it was, but actually it wasn't. It was this decision that predates the Santa Clara decision by decades. So important to understand that. All right. So what the heck can people do? A couple comments, suggestions in the chat. Hold a rally outside the school with signs. Whoops. Slave Lord Law School and get it to the media. Anything else? I mean, what comes to mind? What would you suggest we could do, Taru, to help the cause?
Well, so one of the signatories on the letter that we presented to the dean, he noted that, okay, so one of the ways in which the Washington Redskins changed to, now they're called the Washington Football Team. The owner, Dan Snyder, had sworn he was never going to change the name. But shortly after George Floyd, a bunch of sponsors said, we're going to pull out unless you change the name, because of the kind of the atmosphere after George Floyd. And so 3 weeks after he was threatened with these billion-dollar sponsors to pull out, he changed the name. And so I guess my question is, who are some big money sponsors or donors to Cleveland Marshall that might be willing to pull out of their sponsorships of the school? That would be my question. If there are any that that agree with us, basically, because the old saying, money talks, right?
Right.
Could
Other
I
suggestions?
say
Go ahead.
something? I'm
Go
Jack.
ahead.
See, I'm a graduate of Cleveland Marshall Law School, 1988, and I didn't know that John Marshall was a slave owner. That was never mentioned in constitutional law class. And he is, in the context of constitutional law, he's presented as a hero because he established the principle of judicial review, which gave a lot of power to the courts and made it a co-equal branch of the government. Without that, who would care about the courts, really, in terms of reviewing the law? And I'm a pretty well-read, well-educated person. I didn't know. So I think the problem is largely ignorance. The people of Cleveland probably don't know this. The people, students at Cleveland Marshall today probably don't know this. So I think probably the first step is an education program. How could we get the word out that this is the case? And maybe a law review article, get someone to write a law review article about it, might be helpful in the Cleveland State Law Review. But somehow, letters to cleveland.com, somehow this information needs to be more widely disseminated.
Right.
Well, I should mention, so there is a man named Paul Finkelman. He wrote a book called Supreme Injustice. And that's where he discusses John Marshall and also Joseph Story and Richard Taney, or Roger Taney, as far as their kind of pro-slavery jurisprudence. And he's been very good on talking about John Marshall. Like, he's written some stuff on the, I think, University of Chicago legal blog or something. And I did, the Scene magazine published a piece that I wrote on this issue in late December. And also the American Constitution Society published a piece that I wrote on John Marshall last September. But, just one thing I would like to add before that, speaking of judicial review, one thing that's kind of interesting with that Marbury versus Madison case, again, this all comes back to the issue of conflict of interest. John Marshall decided this case, and he was involved in the fact pattern as the Secretary of State. So here we have John Marshall deciding a case that involved him in his previous capacity as Secretary of State. Talk about conflict of interest.
Yeah.
So it's kind of laughable. And I was thinking about this because Donald Trump has lately been trying to figure out if he can pardon himself, which is absurd on its face, right? It's absurd, but nevertheless, he's wondering about that. And I'm like, well, John Marshall deciding a case involving him as Secretary of State is as absurd, really, as far as, again, the conflict of interest angle.
Yeah. Same thing as Georgia. with the governor, with the guy in Georgia that ran the election as Secretary of State. The same stuff, no matter where you go.
And one more quick suggestion I would have is, we wouldn't have to change the name that much. We could change it to Thurgood Marshall Law School.
Yeah, right. That sounds good.
Yep. Well, it's been suggested, a couple of comments about doing stuff, street stuff, protests. I don't know if any of the people, Taru, who are part of this campaign have thought about showing up, outside either just before the vote, or I don't know, when students are going in, or students may not even be meeting on on camp. I don't know if it's virtual or not these days, but any thought as to doing something demonstrative somewhere with signs to let the press know?
Yeah, that's a thought. And also, RP, you were just speaking about as a Cleveland Marshall alumnus.
Yes.
So I'm understanding that one of the Marshall students is trying to organize or help to put an alumni organization on this together. So if you could share your information with me, I'll put you in touch with her, and maybe you could help with the Marshall alumni, because we're trying to get Marshall alumni to really be at, we need Marshall alumni on board.
Okay, I'm happy to do that. How do you want me to get my information to you?
I guess just send it to me in the chat, your email address, and then I'll send you some info. Yeah, if any Marshall alumni are on this right now who want to get involved, please send me your email address.
Or if you know of any. Taru, if you could send me the links. I know I had them once, but if you could send me the links to those two articles, the one in the Scene and one in the American Constitution Society, I'll send it out to everybody who's on this call, as well as everyone who registered, with an invitation that if any of you, either are alums or know of alums, contact you.
Okay, yeah, that would be great.
Okay.
Awesome.
Any other comments before I turn it over to Steve and then Lois to close?
No.
Okay, Steve, you have any other? Back over to you.
I don't have anything in particular. Thank you so much, Tara, for speaking on this. It's a very important issue. And Lois, if you want to, say the upcoming.
Yeah. Hi, everybody. I'm Lois Romanoff. I'm co-chair of Cleveland Move to Amend with Steve. This was wonderful, Taru. Thank you so much for this information.
Thanks for inviting me.
So we need to understand more and get involved. I think the idea of getting the alumni involved is an extremely good idea. I want to just mention two things. The next Cleveland Move to Amend meeting is going to be February 13th. That's on a Saturday, and probably at 11 o'clock. I'm not sure of that. So we are going to begin working on our Democracy Day. And I'll tell you about that. That's my second announcement, is that Cleveland Heights is having their yearly Democracy Day on Thursday, the 28th of January. And that will be a time when people get 5 minutes to be able to talk about the problems of corporate rule and in all of its many facets. So that's going to be on Zoom. It's usually at Cleveland Heights City Hall, but of course we are not going to be able to do that this year. So anybody can come and give a 5-minute presentation on the problems of corporate rule. So those are the two things that I wanted you to know about. Is there anything else, Steve or Greg?
Just that Democracy Day, people usually pick like one issue and talk about it for 5 minutes. So feel free.
Yeah, I'm going to be talking about the privatization of the public schools, which I'm very worried about and have been talking about for a long time now. Steve, what you have something going. You're going to be talking about the police, I think.
Oh yeah, with Acre, like the Action Center for Raising the Economy had a good thing on police brutality bonds, so I'll probably try to speak on that. Cleveland is a one of the like case studies. They had 5 case studies, and in light of the consent decree for the Cleveland Police Department ending soon, and we hope it's going to be a campaign to try to retain the civilian oversight. So I think it's timely.
Mm-hmm. Yeah, right.
And there's a conflict of interest there too, right? The police brutality bonds and
right.
Yeah.
Brecksville is having its final Democracy Day on February 23rd. We had a sunset provision 10 years. So our final one is February 23rd at 7 o'clock. It'll be by Zoom.
Wow, you already reached your 10-year deadline. That's amazing.
We did.
That's great, wonderful. It's been going on for 10 years.
Well, send us the link, Jack, and we'll get the word out. If anybody can participate or at least watch.
Right. I think speaking is restricted to Brecksville residents for the most part, but you know, if Greg, you've spoken before, and we get prior permission, speakers could speak. So, and we'll probably need speakers, so that would be good. Yep. I will get the link to you, Greg, and then maybe you could get it out to the group. Okay. Thank you.
Great. Well, thanks everybody. We really appreciate it, and came in 10 minutes under. So wonderful.
Thank you.
If I could tell a short story, I promise it's brief. Is it okay?
Yeah.
Go ahead.
This is regarding our topic today. So I was at a rally yesterday to get justice for Tamir Rice, as the federal U.S. Department of Justice has declined in prosecuting the shooters of Tamir Rice and the driver of the car that, went up on him so close. So there was a rally yesterday called by Samaria Rice and Black Lives Matter Cleveland and Black Spring Cleveland. But the people that came were from all over the country, and they represented the Black Panthers, the new Black Panthers and the original Black Panthers. Some of them were there. But the interesting thing was they were observing their open carry permits, wielding rifles and that. And they were very serious, and they weren't, aggressive like you see with the white supremacists with their rifles and whatnot. But we marched from the Justice Center to the federal courthouse, blocked off the road with bicycles from some of the local white activists, food not bombs and that, and redirected traffic around West 9th. And I didn't get a picture of this one, but even a police car honored the blocked traffic. So it was a good rally yesterday. Thank you.
People's police.
Police in Cleveland have actually been very good about allowing protests, legitimate protests, to take place. I don't think we've had anything like the rioting on January 6th.
One thing I do, the one point of controversy is whether or not police instigated violence in shortly after George Floyd. I know one person who had rubber bullets shot at her, and she was a legal observer. And so that's one of the issues, whether or not the Cleveland police attacked people who were just peacefully protesting.
Well, on May 30th, that did happen. There were some terrible things that happened. For the first half of that George Floyd demonstration was wonderful, from about 1:30 to 3:30. I was there, and we left at about 3:30, but all the trouble started right after that. And the Plain Dealer put out a big article about how they blamed the police for not being ready. And I think they talked about some of the wooden bullets actually seriously hurting people.
Yeah.
So that's exactly what you're saying. So that was not a good example of, that was a good example of what should not have happened. And I've done a lot of protesting before that and have never experienced anything like that. So things were different on that demonstration.
Yeah, I'm not so sure it's controversial. I think it's been pretty well shown now the police initiated the violence.
Yes. Right. So I'm glad you mentioned that.
Same thing's going on in Columbus, right, Bob? I mean, stuff is, geez.
I was about to jump in and say that during one of the protests against George Floyd, a U.S. congressional representative, who happens to be a woman of color, was tear gassed along with an African-American mayor is the wrong word. Somebody on city council who was with her was also tear gassed.
And when was that? Also at the,
I'd have to do a lot of Google searches. But there've been 1,800 protests since last summer. Some point in downtown Columbus, there.
Black Lives Matter.
Yeah, it was in response to George Floyd. It's probably 3 or 4 months ago now.
It was July and it was Congresswoman Joyce Beatty.
Right. I didn't name her because you're from another part of the state mostly.
Oh, sorry. Oh, well.
Yeah, no.
So she's not one of the 5 neo-Confederates that tried to overturn the election.
Actually,
in Ohio, we have 5 representatives who are neo-Confederates who tried to overturn the election. Jim Jordan and company.
Jordan.
She wrote a very moving piece about what it was like to be in Congress during that event. I mean, I didn't hear from my congressional representative who's a white man, or the other one who's in this area, but I heard from Joyce Beatty the next day. She wrote about a first-person account of what it was like to be there and to be escorted out of the room and so on.
Good, glad she did that. Quite a conflict, isn't it? And quite a hypocrisy in which white people show up to the Capitol with arms and they sort of end up being, in many cases, just escorted out, or, you know, they leave, but a young African-American boy with a toy gun gets killed.
Right. Good example.
Okay.
Thank you,
So
everybody.
long, all.
Thanks very much.
Thanks again.